Hello everyone, welcome to Courts Today by LiveLaw, your one-step destination for the latest and fastest legal updates. I am your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. The Supreme Court has now taken suo motu cognizance of the rape and murder of the doctor in Headgear Hospital in Kolkata. A bench comprising Chief Justice of India D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra will hear the matter tomorrow. As you know, that the body of the postgraduate trainee doctor was found in the Headgear Hospital's seminar room on 9th August. The Kolkata police arrested a civic volunteer the next day in this connection. On 13th August, the Calcutta High Court directed the CBI to take over the investigation after expressing lack of satisfaction with the Kolkata police. The High Court passed the order acting on petitions filed by one of the parents of the victim and certain other individuals. Also recently, the High Court pulled up the West Bengal machinery for acts of vandalism at the hospital during protest on 14th August. The Karnataka High Court has clarified that failure to wear protective headgear as required by Section 129A of Motor Vehicles Act, though constitutes a contributory negligence, will not drastically affect the compensation awarded to a claimant who has suffered. A division bench of Justice K. Somashekar and Justice Chilakur Sumalatha said so while deciding an appeal seeking enhancement of compensation awarded by the Motor Accident Claim Tribunal. The tribunal had awarded 5,61,000 as compensation to the claimant here, and in doing so considered that he was found travelling without wearing a helmet, thus violating the motor vehicle rules. The claimant claimed that he was a manufacturer of wooden toys and earning up to 35,000 per month. Due to the said accident, he had lost his monthly income. He had spent a sum of 10 lakhs towards his medical treatment and other incidental expenses. Thus, he had sought that the compensation should be increased. The bench, interfering with the order of the tribunal, noted that under Section 129A, that is the offence of not wearing protective headgear, attracts a fine of Rs 1,000 or suspension of the driving license for 3 months. Given this relatively minor penalty, reducing the insurance claim amount by 10 to 15% due to non-wearing of protective headgear was unjust. Accordingly, it modified the tribunal order and enhanced the compensation to 6,80,000 rupees. The District Court Pune has dismissed the trademark infringement suit filed by US food giant Burger King Corporation against Pune's iconic eatery Burger King. The US company, stating that it started selling burgers under Burger King label name in 1954 and is presently the second largest fast food hamburger company in the world, had filed this suit in 2011 seeking a permanent prohibitory injunction against use of trademark Burger King by the proprietors of the Pune eatery and also damages of 20 lakhs. Upon applying for trademark registration in India in 2009, the US company discovered that the Pune eatery was already operating under the same name. However, the defendants, that is proprietors of the Pune eatery, argued that they had been using the trade name since 1992. They also contended that the US company had not used the trademark in India for nearly 30 years since registration. District Judge Sunil G. Ved Pathak ruled that the US company Burger King, which began providing services in India under its trademark in 2014, could not claim perpetual injunction against the defendants who had been using the trademark for restaurant services since 1991-1992. The judge noted that US company did not provide evidence of trademark registration in India before 1992 and its registration only dates back to October 2006. Thus, the court found the plaintiff had no cause of action and denied their claims for damages, retention of accounts and perpetual injunction. In the next update, the Gujarat High Court has upheld cancellation of an LLB degree of a person after discovering that his graduation certificate used for admission was fraudulent. Mehul Champaneria, who completed an LLB degree from Veer Narmad South Gujarat University using Bachelor of Arts degree from Sridhar University, was found to have submitted fake documents for his admission. After the Bar Council of Gujarat raised concerns, Sridhar University confirmed that Mehul had never been a student and that his certificates were fraudulent. As a result, his LLB results were annulled and an FIR was registered against him. The court dismissed the need for further inquiry now, emphasizing that the fraud was evident and that the annulment of his results was justified. Dismissing an appeal challenging the single judge's order, the division bench comprising Chief Justice Sunitha Agarwal and Justice Pranav Trivedi affirmed the respondent university's decision to annul the petitioner's LLB results. The bench observed that the petitioner, having committed fraud, could not seek court's leniency on the grounds of not being granted a hearing. The court noted that when Sridhar University verified and confirmed that the petitioner was never admitted and that the mark sheets and other documents were not issued by them, granting a hearing would be meaningless. In another update, the Kerala High Court has dismissed a petition challenging Hindi titles given to the 3 new criminal acts, namely Bharatiya Nagrik Suraksha Sanhita, Bharatiya Nyay Sanhita and Bharatiya Sakshay Adhiniyam. The petition filed by an advocate alleged that the Hindi titles to these acts can cause confusion, ambiguity and difficulty for the legal community of non-Hindi or non-Sanskrit speakers and thus infringes their fundamental right to occupation guaranteed under Article 19(1)(g) of the Constitution. He had also submitted that Article 348(1)(b) of the Constitution mandates that the authoritative text of all acts shall be in English language. The question whether title of an act comes under authoritative text was a point argued before the court. The Council for the Union of India had also submitted that the title is written in English letters only. The judgment dismissing the petition was delivered by Acting Chief Justice A. Mohammad Mustaq and Justice S. Manu. And lastly, the Allahabad High Court has denied bail to a priest who has been booked under Section 377 of IPC for allegedly committing unnatural sex with a 12-year-old orphan near a temple in February this year. As per prosecution's case, the victim, a 12-year-old boy who had already lost his parents, had gone to see the fair, and when he did not return, his uncle went to search him and found him crying. When asked, the victim said that the applicant accused had taken him away near a temple and had performed unnatural sex with him. Consequently, the accused applicant was arrested on 10th February. The accused argued that he was falsely roped in the case as the child's uncle wanted him to be removed from the temple and thus a false FIR had been lodged against him. But the court found no prima facie reason to grant him bail. Considering the gravity of the offence and the victim's statements deposing as to how the alleged act had been performed by the accused, a bench of Justice Rohit Ranjan Agarwal denied bail and observed that the offence had shaken conscience of the court. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.